Good morning, everyone. Hi, I'm Tom Keck from Syracuse. Welcome to day 3 of the Bergen Exchanges. I'm moderating our first panel today. The panel is entitled Speaking the Law, How Language Shapes Legal Power and Meaning. And among the questions we're going to be considering are how the words we use to talk about law and legal mobilization influence how legal authority is constructed, contested, and understood. So I'm just going to briefly introduce my 3 fellow panelists here. To my right, they're going to speak for 10 minutes each, and then we're going to open the floor to questions, and then hopefully we'll have some time at the end to return to the panelists. We're going to go in the order that they're listed in the program. So we'll hear first from Gökhan Sen from University of Oslo, and then Jeff Tonmaker from Erasmus University, and then Tevfik Can Peker from Kadir Has University in Turkey. Gökhan I've known for several years now from these events. Jeff and Tevfik I just met this week, but already starting with the hike through the mountains, we had great conversation. So I'm really looking forward to hearing from all 3 of you today. And so Gökhan, the floor is yours.
So I think that you relate with the feeling, with my feeling, when you're scrolling through, imagine yourself, you're scrolling through Twitter, Blue Sky, or LinkedIn to see whatever is trending, and you see the hashtags like abusive constitutionalism, autocratic legalism, constitutional road, constitutional dismemberment, constitutional hardball, populist constitutionalism, anything. And you can also imagine the bamboozling legalism, shenanigans of the constitutional law, etc. So your attention is hooked there, and they sound urgent, they sound very catchy, they sound important to you. And as a concerned citizen, and also with your academic curiosity, you are drawn into this to hermeneutically understand and brew your brain in what all these metaphysical and magical terms may refer to. But pause for a moment here, and what do they actually mean? Do they intersect? Do they have any interaction with each other? Do they overlap? Are they coterminous with each other? Or do they refer to something which is older even? Or have they just become simply part of our catchphrases when we want to just fill our theoretical voids? So I'm a little bit skeptical about these terms. So my upcoming chapter on the book titled, is it on the screen? Yeah. The Language of Comparative Constitutional Law, Questioning Hegemonies, and the chapter's title is Untangling Buzzwords, Making Sense of the Vocabulary in Anglosphere Constitutional Law Literature. I dare to call them buzzwords without necessarily mocking these terms or without necessarily pointing fingers to the authors or to the researchers who endorse them, which some of them are friends, some of them are colleagues, some of them are senior professors, which I have met personally, which I read and learned about them. So there's nothing about condescending of self-righteous here. But first starting with a little bit of frustration when reading this literature, and then trying to make sense of it, maybe to create sense of sort of discussion and maybe or conceptual mapping of these terms for some. At the end of the chapter, I decided to leave all these terms together, but it's a personal decision from my part. But as if you read this chapter, you can use it for your purpose to navigate and to map on your conceptual understanding from whatever you're coming from, law. And if you are, particularly, I'm trained in a civil law, continental European law tradition, so that's destined primarily for these audiences, but anybody, particularly coming from Global South, having civil law traditions that their doctrine could have been affected by Spanish or Portuguese or French authors, so that will be helpful, I hope. So, without being condescending again, I said a recent work revealed that there have been, since 1940, there are 564 adjectives that qualify the concept of constitutionalism. So I think it was Kapievsky and her friends. I thanked her because she wrote everything that I was intuitively resenting and being frustrated, and she wrote it down for me. And I really grounded my argument, first argument, that these adjectives may have been useless. That's the hypothesis, only that hypothesis. Because, over these 564 adjectives, there are 78 adjectives. They were classified as outliers, which means that they mean nothing for their research or for their classification. And one of them was strikingly the word abusive, the abusive constitutionalism. And the author said that is it just for author's personal views on what he sees in a given moment and at a point, at a political context. Again, language shapes our thoughts. Yes, the dominance of English in academic communication is a bliss. We are here thanks to English as a lingua franca, but it also comes at a cost. It also carries the baggages of Anglosphere, Anglo-Saxon way of seeing the political community and the law, which is completely different, well, from many perspectives, completely different from continental tradition, law tradition, where the state with a big S is the central pivotal concept. And in this terminology, we don't have this compass. So in this chapter, I try to put this compass as a way of mapping these terms and try to make sense of them. This tradition, the continental comparative law tradition, treats the state from Hegel or from medieval times as like a godlike personality, like a deity, which replaced during the Age of Enlightenment the very God itself. Now there is a state with a big S, another abstraction, another personal deity which sits on the over all of us. And from a personal perspective, as a kid, I literally thought that the state was someone sitting above the sky, watching over us. And some of you may think that it is one of the symbolic political symbolism who is grown up in an authoritarian political setting. But no, this is the concept coming from Italian Machiavelli and ranging to Russian Tsarist way of seeing things. So this is the old concept of state as a god, covers Europe, Turkey, Russia, and also all the way to China, even in the Central Asian countries. Having said, language shapes our imagination, and the continental European tradition sees the state, sees the constitution as a legalized form of state and its limitation. Then I clustered these new buzzwords first into three groups. One is first the reinvention of the old state law conundrum, where the state is both the creator of the law and should be limited by it. This is our paradox in legal theory, and for 200 years we have been pondering, but there is no definite answer. But the terms that ostensibly try to give definite answers is a little frustrating, which we say autocratic legalism, constitutional hardball, again, abusive constitutionalism. Abusive constitutionalism is mainly a very descriptive point which paraphrases the only concept of the limits of the derived constituent power, the limits of the constitutional changing power within a state. And also constitutional dismemberment, for example, which is a 75-page long good article, very analytical, but it fails to mention even Schmidt's absolute constitution. It mentions to fail the difference between material and formal conception of the Constitution. And it just says that if you change one constitutional provision, then all Constitution collapses, which we have been, again, discussing with no end in 200 years of continental European state theory. And another term that I take issue was lamentations, which I have been the most critical. Oh, my constitution is that evil guy came, and no, there were no democracy. Hey, welcome to the club. Constitutional erosion, constitutional decay, constitutional retrogression, constitutional rot. No, I say, these are not. Rot is sociological, erosion is cultural, decay is, again, cultural, retrogression is in the rights and democracy, it's not in the constitution. So overflows these terms to create this crazy hyperbolic mindset is also, from my perspective, not good for analyzing the very crisis that we are passing through during this era. So further below in the text, I try to make sense of other adjectives. So I choose, and I again put the state as a compass. One is discussing the alternating legitimacies, which we take freedom, consent, and justice, and what is the role of the state, and which is the balance. So then I say there is the dichotomy of liberal and social constitutionalism. Liberal is American Hayek, and the social constitutionalism is Sozialstaat in Germany. And then from social constitutionalism, we see the state as a benevolent brother, like coming from French, l'état instituteur, coming from French, that transforms the society. Transformative constitutionalism cures the past injustices, and egalitarian constitutionalism, India, egalitarian, transformative South Africa. Then we have counter-legitimacy, which is, again, a historical thing. from Metternich here in the 19th century, where on that era, coming from Machiavellian thought of the state preservation, to preserve the state, you have to give a little bit of the rights to ease the revolutionary demands so that the people are appeased, but not too much. That has to be a mixed government. So again, Aristotle, it's very old. But Metternich says that we give a little bit of freedom, but the real power stays in me. Then we have conservative constitutionalism, authoritarian constitutionalism, illiberal democracy, or is it illiberal constitutionalism? I don't know. So too many names, you name it. And I came to realize that it is, again, readers' decision to use them for their own research. But then I decided that I think we have to leave the words and terms constitutional and constitutionalism alone, because when there are too many signifiers and qualifiers, it means there's nothing. It's just an empty signifier. Then I concluded with that, which I criticize myself because I've also used these terms in my old publications, not because they were analytically useful, but because they were catchy and popular, because I just want to get cited. I just want to be relevant. So I just have to say that. And I have to be honest about it. Thank you very much.
Thanks, Gökhan. Jeff, the floor is yours.
Thank you very much, Gökhan, and to the organizers of this truly wonderful event. I'm very, very pleased that I came and listened to Jackie's advice, which she's been giving me for many years. So Jackie is connected with this project, as are several people in this room, and this project being the Legal Mobilization Platform. So I'm going to talk about what is legal mobilization, and also more to the point, what it is not. And again, referring to what Tom said at the outcome, it's about, again, the words we use to talk about law and legal mobilization, and how that influences how legal authority is constructed, contested, and understood. So Siri said in the first session here that we're talking about the use of law in that really powerful first session in autocratization and resistant strategies. So my work has argued that there's an important distinction to be made between different uses of law, and in particular, what is legal mobilization, how it is conceptually different from lawfare. So what legal mobilization is not? Well, I mean, legal mobilization as a form of counterpower, which is the really important contribution that my colleague Sanne Takama introduced to this project, forms part of a broader concept involving these different uses of law. And again, it should be contrasted with autocratic lawfare, as also characterized by our colleague here, Daniela Rashed, which seeks to use law often in an arbitrary manner to undermine civic accountability. So for example, while legal mobilization would seek to pursue litigation to hold corporations accountable, corporations instrumentalize law, drawing on their deep pockets and engaging high-powered law firms, which you also heard reference to at this event, to prevent litigation through slap suits and the like. While legal mobilization seeks to defend or protect political dissidents, suppressive regimes, autocratic regimes, I should say, instrumentalize law, drawing on the control of police and security forces in order to silence political dissidents through surveillance, prosecution, administrative detention, and other dreadful means. So the potential, obviously, for conceptual fuzziness is there, as our colleague Satang also mentioned at this event, where free speech can be mobilized or weaponized, depending on who's using the law. So here, as illustrated, lawfare is a term used to deplore United States efforts to destabilize democratic Latin American regimes, yet it's also weaponized by CPAC, which has also a Brazilian chapter against those same regimes. It's also used as a term to undermine ACLU, American Civil Liberties Union, Greenpeace, and other legal mobilization organizations. So to maybe try and find more traction in making this conceptual distinction, we can again look at the sessions that have taken part in the last few days. As several participants have asked, what is the strategic objective? Well, again, referring to Daniela's work, to weaken or to preserve Brazilian democracy. As Georgiana said also in that powerful first session, to capture state institutions, or as Payam explained, to protect the independence and legitimacy of those institutions. To weaponize exclusionary national identity, as Namita explained to us in context of India, or to nurture inclusive national identity and community, as Rachel explained. And again, in Savati's keynote address, to disenfranchise women. Very, very embracing, and well, not embracing is not the word at all, very catch-all type of lawfare objective. And to turn people against each other, and I couldn't remember who said this, but I think that this is really important objective of a lot of lawfare organizations. So the use of law can take myriad forms, or rather, different strategies and tactics. And here it's important to differentiate, just as between legal mobilization and lawfare, between the strategies to address systemic or general goals and the tactics in between, which are to pursue specific goals in pursuance of a larger strategy. So strategies can take, as I have in this matrix, confrontational or cooperative types, including whether, for example, as again referring to an earlier session, to focus on the trauma of what had happened and the healing that needs to happen in relation to transitional justice issues, or the dehumanization of why something happened in the first place, and the potential for rehumanization, which is a project I'm working on now with colleagues in the Netherlands on confronting the Dutch slavery and colonial past. And then tactics, right? Through truth commissions, international courts, people's tribunals, shaming, protest, strategic litigation, and many other different forms. As Adrian said, one should not emulate the strategies of the right wing, though one may share similar tactics. And I think this is also a very poignant remark. And then Io mentioning that the feeling that marches about a single topic may not necessarily be helpful or relevant for the broader strategy. Again, to reiterate, the tactics may be the same, but strategies tend to be fundamentally different. So analytically, beyond my conceptual distinctions, I'm looking, and I'm not going to talk about it here because I want to hear from you more, but I do talk about the capacity to mobilize, the opportunities for translation or structural change, drawing on Sally Engelmary's work, and then finally, drawing more on Martti Koskiniemi and others, navigating and leveraging also the structural institutional bias contained in law and legal institutions. So the focus of my future research is going to be on actually the future of human rights law, or more importantly, the possibilities for legal learning, where cooperation between scholars and activists and the sometimes multiple roles that we fulfill, I have a hard time with the idea of being a scholar activist, because I think that collapses very different kind of roles, but I don't have any problem with being a scholar or an activist. It's just that you're fulfilling different roles at different moments. And I think for the strategic point of view, it's important to be clear what it is that you're seeking to do. Okay, that's just that statement. So in this case, which again refers to a statement made earlier, but I think it was Kristen, if I'm not mistaken, she asked, well, why isn't anyone going after the humanitarian, Gaza Humanitarian Foundation? Well, legal status. Actually, they are, they being the Center for Constitutional Rights in New York, which is also a member of the Legal Mobilization Platform. And wonderfully, Tom, I'm within time, so I can say something about, I think, a very complementary entity to this, again, wonderful gathering, which has been going on for so many years. And that's the Legal Mobilization Platform. So Wittgenstein, I understand, is also relevant to Norway? Yeah? His house is somewhere north of here. Not so far north. Well, he, of course, created this image of the duck rabbit, which is, in our understanding, used, and actually Martti Koskiniemi introduced this idea of the language of the ducks and the language of the rabbits, the ducks being the lawyers who tend to talk way too much. And thank you. See, multitasking. There's the duck rabbit. That's why you were all looking at me confused. Whereas the rabbits, being social scientists, I work in an institute of rabbits, the Institute of Social Studies, who look at me as a duck, rather deploringly sometimes. No, I'm being too frivolous. But yeah, we do have some different perspectives. And I think that it's really important to take law and politics very seriously. That's the more serious point here. So we were founded in January 2023, but it's part of a longer conversation. We're a new type of platform, but we shouldn't be too new, and clearly Bergen Exchanges is very much has a similar heritage. A network of people and organizations who are involved in advancing human rights more broadly. And what we do, well, to give an example of that, would be a project of the organization Systemic Justice, which I think relates a lot to Gökhan's talk here. Systemic Justice has a project of intersectional rewrites, which is rewriting decisions of the European Court on Human Rights and Fundamental Freedoms in a language that would have taken into account intersectional characteristics of these cases. It's a beautiful project. The book is edited by Nanny Janssen, an advocate in Britain and in the Netherlands, and it'll be published sometime later this year. So yeah, I leave again with a minute to spare here with, thank you, this slide, which is extending an invitation to all y'all to reach out to us, become a member. It doesn't cost anything. We have an email list server, which is not a lot of traffic, I'll let you know. It has more than 350 individual members. We have about, now 40 partner organizations. And our advisory board is composed of not least Jackie Dugard, again, well known to you all here, Ambrina Manji, who, by the way, is also involved in issues around academic publishing and academic writing, and I think would also be someone to consider reaching out to. And Gloria Vecker, involved in intersectional issues in the Netherlands. Yeah, and finally, Milon Kutari. Please do reach out to us. If you want to know more about the platform, I'm happy to talk about it. And thank you again so much for inviting me to be part of this wonderful event.
Thanks, Jeff. Tevfik, the floor is yours.
Thanks a lot. I will try to not to bore you after these two wonderful speeches here. I am Tevfik Can Peker. I am from Kadir Has University. I'm a research assistant at Kadir Has University, and I am a PhD candidate at Marmara University in public law. Today I will talk about something related to my PhD thesis. It derives from that, we can say that. My thesis is mainly focusing on the decline of the laicite or laicism in Turkey, the constitutional principle of laicism in Turkey, in terms of countries' integration into the capitalist world system. So when you also look at if you look at my poster there, I use the laic, laicism, laicite a lot in an English poster. So I will start from that, because the English literature, we often see secularism instead of laicism or laicite. Secularism is often widely used, but I will talk about these two concepts, these two translated or adopted or borrowed concepts into the Turkish language. Two terms, one come from the English, one come from the French. Maybe we can think that one come from the continental law tradition and one come from the Anglo-American tradition in some senses. So I want to begin with the terminology a little bit. Laicism or laicite comes from the Greek word laikos. That means that common people, we can say, or non-clerical, the people who are not from the clergy. And in laicite, in our understanding in Turkish, there's a huge difference between secularism and laicite. We take them as two separate concepts most of the time. Laicite relies on a strict separation of religion and state even takes active role on regulating religion and its visibility in the public space as well. And laws, especially regarding public service, cannot be derived from religion. And historically, laicite also has the memory of the conflict between the active conflict between the church and the state. But secularism, on the other hand, which comes from the Latin word saeculum, secularis, meaning worldly, or from this world, maybe we can say. It understood, especially in the Turkish case, in a context as a more gradual development, often less strict than laicite, a more evolving manner, other than laicite has we tend to understand it in a more struggleless manner, maybe I can say. And I would like to turn to the historical development in Turkey in this sense. Also, maybe I should say that before turning to that, I have still my time. The emergence of these concepts, mostly in Europe, and we adopted them through that development, especially in the continental Europe, we can talk about the transition from feudalism to capitalism. This process, especially I took it in my thesis from this point of view, created this separation between the state and the church, the understanding. There was a struggle for the separation. But in the Turkish case, historically, I can say that it was not quite the issue. Maybe I can little reflect on that. In the Ottoman Empire, we are talking about the not separation of the, not a struggle for separation of the religion and the political power, but we understand them as a whole, as one. And we often considered Ottoman Empire as a theocratic state, yes, but in the classical period of the Ottoman Empire, we see that religion is under the control of the monarch, the Sultan itself. So religion wasn't an element to limit the power of the Sultan. It changed with the decline of the empire. And during the foundation of the modern Turkish Republic, it was also the case that controlling the religion should be under control of the state. It starts with maybe we can start with the 1999, but in 1937, laicite became a constitutional principle in Turkey, along with the sixth principle of Kemalism, republicanism, nationalism, populism, statism, and revolutionism. And to understand more of the Turkish classical understanding of the Turkish laicism, maybe I would like to read some highlighted parts from the decision of the Turkish Constitutional Court from 1995. Court states that according to a common but insufficient definition, laicism is the separation of religion and state affairs. But it has these following principles as well. Religions shall not influence or dominate state affairs. All religions shall be constitutionally guaranteed without discrimination. In aspects of religion that extend beyond the individual's spiritual life and affect societal actions and behaviors, restrictions may be imposed to protect public order, security, and welfare, and the misuse and exploitation of religion shall be prohibited. And the state, as the protector of public order and rights, shall be guaranteed oversight authority over religious rights and freedoms. Maybe as Professor Shen stated, state here is controlling everything over the religion itself, and it has some active duties to control the religion. So this is mostly, by their critics, the understanding is mostly called as the militant laicism, and the religion must stay private and a collective inner matter of the individual. This was the main problematic of the Turkish politics, maybe, from a long time, I can say that. So the main aim of us here to limit religion as a spiritual matter and not to extend to the public matters, especially in the politics and such, in the law domain as well. But this understanding of the Turkish Constitutional Court changed in 2012. There is a new decision, and Constitutional Court redefined the principle of laicism. And they say that according to the strict interpretation of laicism, religion is a phenomenon confined solely to the individual's conscience and must not extend into the social or public sphere in any way. The more flexible or libertarian interpretation of laicism does not confine religion solely to the inner world of the individual, but considers it an important element of both individual and collective identity, allowing for its social visibility. In a laic political system, individual choices regarding religious matters and the lifestyle shaped by these choices are beyond the interference of the state, but are under its protection. In this sense, the principle of laicism is a safeguard for freedom of religion and conscience. So this redefinition of the principle of laicism here brought us that there's a big shift that principle of laicism being the protecting society from religion to one protecting religion from the state intervention. And at the first glance, maybe this decision can be seen as the broadening of the freedom, but I am not totally agreeing with that. I think this interpretation undermines the essence of the laicism itself that described in the first decision of the court. And it reminds me, when I read the whole of the decision, it reminded me the decisions of the European Court of Human Rights on the Article 9, freedom of thought, conscience, and religion in that sense. So it undermines the principle of laicism solely to the freedom of religion and belief, this decision. And especially in the French model that Turkey adopted or influenced, we can say that it was never just only about the individual freedom, maybe I can say. It was ensuring that the religion could not dominate law, public order, and political discourse as well. But in this new interpretation, religion is not only tolerated, but it is legitimized as a collective social force given public visibility and turned into a discourse through which political consent is produced. We can say that it is turning more and more into an ideological tool. And while the principle of laicite, laicism is still inscribed in the Constitution, what we understood from that is what we should understand from that according to Constitutional Court, gravely changed, we can say that. And there is this, I can turn back to maybe the secularism debate. There is this problematic in the beginning of the 2000s, the first decade of the 2000s. I remember the discussions in the Turkey about that. The discourse was more or less like this. Turkey adopted the oppressive French model between the separation of state and religion, but there is the US model or the British model, which is less strict, which allows more visibility for the religion as well, which there's something lost in translation and consciously lost in translation, I can say, in this last minute of mine, I guess. There is also the separation between the state and the church, state and the religion in the secular models as well, especially in the US. Constitutional level, we can see that, as far as I know. But that part is consciously lost in translation, and the highlight was on the religion's influence and visibility and effect on the society. So, at the end of these debates in 2012, we see this change in the constitutional course and using the discourse of more liberal lexicon, maybe we can say that the freedom discourse is used in this sense of the Constitutional Court decision. But as it was highlighted in the Monday and yesterday's sessions as well, using this discourse can lead to erosion of the rights and freedoms in the real sense. And I would like to conclude with this, I guess, without...
Thank you to my fellow panelists, and the floor is now open for questions. Thanks so much. Day 3 is off to a great start with audience engagement. So I'm going to return it to our panelists. Let's go in reverse order. So we'll start down there with Tevfik, and you all have 2 minutes each, roughly. Yeah.
Thanks. Thanks for the questions and the comments. About the decisions of the European Court of Human Rights, how they impacted the Turkish legal system. If we are talking about that, I can say that, how can I say? I guess I can say that until the recent years, the judgments of the European Courts of Human Rights had more impact on the Turkish legal system and how we understand some constitutional principles, how we look at the rights and freedoms. Beside from the certain issues that Republic of Turkey has its reservations, other than that, they were implemented in the domestic law most of the time. And if you look at the text and the syntax of the Constitution, also it is similar to the system of the European Convention on Human Rights, how we define rights, how we talk about their limitations and such. But this process, I cannot say it is persistent. I cannot say it is on a flat line, it's going well. It's always like this. I cannot say that, especially in some certain topics lately, we can see that decisions of the European Court of Human Rights are not respected or not implemented in the domestic law as well. So it bring me maybe to this, that understanding the text of the Constitution and the Convention are too much close in most of the senses, in most of the rights, but their implementation differs gravely, and there is the political part of it comes into play, I guess. I can say that.
Thank you very much. Wow, a lot of food for thought. So, Siri, I mean, I think that lawfare is an analytically useful term. I really do. I think legal mobilization is also an analytically useful term. As to whether or not we can use both, I think is really the question. I tend to be persuaded that legal mobilization as certainly a descriptive could apply to also right-wing legal mobilization. I could be more persuaded, and here I really credit a lot to Mikal and Carolina Kosemba, my colleague at the ISS, for that. I was first confronted using actually the term lawfare at the LSA in Boston in 2013, I think it was. I think you were there also? No? All right. Well, in any event, I was confronted by practitioners, basically. You cannot use this term lawfare in describing what you are describing, because this is exactly how they are. They, being the right wing, are describing us. Migrant activists, gender and sexual orientation activists, climate activists, and the like. So indeed, it's not easy to say what is good and bad. I fully agree with you. I do think that indeed, also I agree strongly with Rachel that it's hard to make a sort of firm distinction between the normative and the analytical, although I think we should strive to. Methodologically, Mikhail, this is going to require a much longer conversation, of course. I don't think it's, I think that it's more than just values-based. I think that it is impossible to empirically measure how law is being used. And I think that it requires actually anthropological techniques to disentangle what it is that the users of legal mobilization, here I think of Lisa van Halle, who's a sociologist, but she actually uses quite anthropological techniques in her work. Oh, I'm running out of time here. Very briefly, just here to Dr. Shaw. You answered transformative constitutionalism. I would refer the work of Sanela Sibanda and Bernadette Atuene, who basically say that actually, in that transformative constitutionalism is really not the right way to go. They're very critical of this notion. They consider it to be very reifying. And I'll just leave it at that, but I would love to refer you to their work later on. And along the continuum, Rachel, can we talk about it later? But just very briefly, I would say that it's again about trying to find some empirical grounding for explaining what's going on there. Let's just have a conversation about it. Yeah, thanks.
Thank you very much. So starting from Siri, purely linguistically speaking, Siri is not a political scientist. You are a scholar on the knowledge of state if you speak in Norwegian. So it's coming from statsvitenskap, right? So it is not political science. So it's coming from Germanic conception of the state being the center. But Norway, as you understand, is there a state in Norway? Yes and no. Yes, because it's coming from German conception, but it didn't follow exactly the same historical lines as I know from feudalism to absolute monarchy. And there were some monarchies in Norway, but it was not as absolute as we can see in Russia, Germany, or Turkish Sultan. So that may be the reason of the ambivalent status of the state in Norwegian political culture, as far as I can observe. The second, Tanya, yes, and I have to admit that many of my insights and arguments, I have grounded it with speaking with Italian colleagues, their frustration in these new terms, and their urge to contribute to the discussion from their own perspective, where many of the contributions, if you can read, also tap on that. To the objection, I totally agree. What I wanted to say is we first have to cut down the words as much as possible to make sense of things, what's going on. But my main argument is that adding qualifiers to a concept, multifaceted and very ambivalent concept as alone, like constitutionalism, it has normative connotations, purely legal black letter connotations, and functional political connotations. For example, Dan Briggs was talking about institutional design. This is not much normative. It is for functional things. How can we do things in a good way? This is functionalism. When you refer to legitimizing, delegitimizing, it is the constitutional lawyer's job, and it intersects between morality and law most of the time. We cannot limit ourselves as constitutional lawyers to the black letter of the law. There's always a shift between morality and legality. But this has been discussed again for 200 years, and given these names to these whole discussion from different countries between legality and legitimacy and the intersections blurs my mind, because constitutionalism has facets. And when you add one qualifier to that constitutionalism, okay, I'm just finishing in 40 seconds. And at the outset, it really triggers a very wrong direction. Is he talking about normativity? Is he talking about functionality, descriptive, or is he talking about purely legality? And for example, purely analytical concept can find its place in one Kenyan constitutional court decision, for example, just as an argument. where some other courts say give different names to the same arguments. So my objection was, do not put the same wine into different bottles. So that was my objection. Thank you very much.
Thanks. Please join me in thanking our panelists.